Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. You are watching testimony from the Adam Matos case where the defendant, Adam Matos, took the stand. And we are waiting right now because we're in a recess in the penalty phase of this case. A determination by the jury about whether or not they should sentence that man that you just saw on the stand to death. Right now, the prosecution and the defense are battling it out with separate witnesses to identify for the jury the aggravating and the mitigating factors that will be put forth to them later on today about in their deliberations. Should he be sentenced to death or not? And what will the jury think about? Well, luckily for us, we have with us criminal defense attorney Bob Bianchi to talk a little bit more about it. Bob, good to see you.
Good to see you, Jesse.
Let's talk a little bit about what we have today. So we've seen so far the prosecution has put on two witnesses. They really didn't need to do much, in my opinion. They actually opted not to have victim impact statements put forward. Is that due to just the heinous nature of this quadruple homicide?
Listen, having been a death penalty prosecutor myself, sometimes you have to weigh in a death penalty litigation exactly what evidence you're going to admit in order to preserve a penalty conviction on appeal. And victim impact testimony is very powerful, there's no question about it, but my thought is the prosecution tactically, and perhaps rightly so, said this is so grisly, so bad, let's not pile on with victim impact testimony that could cause an appellate court later to reverse the case.
Because it was just too much. And is it also the fact that, why even put that through the family members? Why make them go on the stand and even have to deal with this? I mean, they're suffering enough. Do they have to share it for a whole courtroom?
Yeah, I don't think the prosecution necessarily is thinking that way. I can tell you as a homicide prosecutor myself, I never did when I elicited victim impact testimony. I think that honestly it's being done for a strategic reason. The bottom line for the prosecutors is they want the death penalty conviction, and they're going to do what they can do to get it. But as prosecutors in death penalty cases, we're very careful, based on so many Supreme Court decisions, that we don't overdo it. And I know it's really hard as a prosecutor to say, well, how much is too much? But when the courts see that the prosecutor was actually curtailing very powerful testimony, sticking specifically to the aggravating factors, then they look at it and they say, the prosecutor used restraint here, so we believe it was fair. And I think that's the reason they're doing this.
Right, I agree with you. I think based upon a relatively short opening argument put forward by the prosecution, very simple, said these are the witnesses we're going to call. It wasn't very dramatic in a way, and I don't think it needed to be. And I think let's just talk a little bit about the witnesses that we saw for the prosecution. Really two, Dr. Noel Palma, who basically testified to the fact that is it not possible that if you look at the blows that were both Margaret Brown and Nicholas Leonard sustained, Nicholas Leonard 21 blows, Margaret Brown 9 blows, we don't know the exact order of the blows, is it not possible that at least one of them, they might have suffered extreme pain, extreme blood loss? They went through this, they didn't lose consciousness at first, and the doctor said, yes, it's possible. Same thing with Gregory Brown, who suffered 2 gunshot wounds. Okay, so the first gunshot wound, they said wouldn't have necessarily killed him. We know that Adam Matos stood over him and shot him again. So that idea that these victims suffered, that he had time to premeditate, to reflect on it, and kept hitting them, kept either bludgeoning them to death or shooting them, that's really going to resonate for the jury. Am I correct?
Yeah, so what the public generally doesn't understand about this is that they look at a heinous nature of a case and they say, wow, the guy should fry, he should go to jail. But that's not the law. There are aggravating factors that are specifically listed, and every state that still maintains the death penalty has an aggravating factor called heinous and cruel nature of the crime. That is, when they're looking at, here you're dealing with a hammer, okay, and you're hammering away at somebody. This is something that's beyond, if you will, the typical murder case. And there's a lot of cruelty and heinousness in the manner in which it's done. So the prosecutor really wants to focus in on the last moments of these people's lives because it's going directly to one of the aggravating factors the jury is allowed to find beyond a reasonable doubt. Each juror has to find each aggravating factor beyond a reasonable doubt to add to that list to say he should be executed, that the mitigating factors don't outweigh the aggravating factors, quite the opposite. We all know from the psychology of death penalty litigation that when you're talking about heinous and cruel homicides, that's your best aggravating factor you've got in all of them. That's the one that resonates the most in the jurors' hearts.
And let's not forget, he admitted it. Okay, he admitted to taking it. I'm not even going to go out of quote here. This is exactly what he said. He was so angry at the end of when he had already killed Megan Brown, he had killed Gregory Brown, and we can't identify the exact wound that eventually killed Nicholas Leonard, but he was so angry at Nicholas Leonard. According to his own testimony on the stand, he took that anger and directed it towards Nicholas Leonard for being the one who apparently brought the gun in the house, who he claimed was the one who started this whole fight. This is Adam Matos' version of the events, that he went back and took that hammer and just started beating him and beating him and beating him. And in the end of the day, it might have been his own words that was enough for the jury to convict.
You know, Jesse, you're bringing up a really interesting point here, and I kind of am intrigued by the tactical decision of the defense here. I think that they put him on the stand not hoping that he would get out of a murder conviction in the actual guilt phase of the trial. I think that they put him on there to humanize him or attempt to humanize him. Listen, every juror that's on that jury has said to the judge that they would follow the law and execute him if the prosecution proved its case. Every juror said that. But we all know that jurors also see the human being there. They see the eyes of the man. They listen to it testify. So he's giving a story that, yeah, I did it, but I was upset. I was impassioned. I was enraged. I'm remorseful. And even though they know that sewing in a conviction, a guilty on the guilt phase of the trial, what they're really doing, the defense there, is humanizing him for the penalty phase of the case, in my opinion.
That's interesting. Let's talk a little bit about what the defense is trying to do. Trying to call family members of Adam Matos, testifying. We saw Rose Matos' mother saying that Adam suffered from asthma. He was constantly bullied when he was younger. He had men in his life who were extremely violent and abusive towards him. He went through a lot. He even went through a car accident, watched his mother, she suffered serious injuries to her chest from this car accident, that they didn't have an easy life. What I thought was good strategy by the defense is he has a brother, right? Similar age, 1 year older. Grew up pretty much the same. He didn't go and kill 4 people, but Adam did. So how much is that going to affect a jury in terms of this? He had a tough life, but at the end of the day, you also have somebody who grew up and didn't do the same things.
Yeah, I think that's going to impact them a lot. I think one of the better arguments that is made in the penalty phase by the defense, if they choose to do it in this case, is to essentially argue that life in prison without the possibility of parole is a far greater punishment than execution is. That's called the aging out experts that they have that they call in there. But they want to be able to say that this guy didn't have a great life, and I'd be careful as a defense lawyer with that for the very reasons that you stated. Lots of us have difficult lives. Lots of us have bad things that happen, and we don't go out and bludgeon people in the manner in which he did. So sometimes I found in the death penalty litigation I've had, even though the judges let the defense lawyers pretty much get out anything that they want to get out, that a lot of times it backfires because it angers the jurors that, wait a minute, that's no excuse that you were bullied and that you had asthma. Come on, give me a break.
Well, I mean, they're also pointing out to the fact that, okay, he was nice on occasion. So we had his aunt testify, and she said, you know, I didn't have a very close relationship with Adam, but when I did visit him and did see him, when he was 5 years old, he played with little toys. He played with little soldiers. Here were the good guys, here were the bad guys. But at the end, he said, you know what, I grouped them all together because I want them all to be good guys. And she goes, yeah, and she said, you are a good guy, I want you to be a good guy. Then she said to him, that he was very protective of his cousin, that she was delayed at the airport, and he stayed with her the entire night, that he's a good guy. These little examples, I mean, come on, we're talking about 5 years old, and one time he stayed with his cousin at the airport.
I think you just hit the nail right on the head. It's not what's being said, it's what's not being said. I think that people would sit there and say, that's the best you can do in terms of things that he's done. He played with little dolls, and he all of them are good guys, and he helped somebody and stayed in a hotel. I mean, in the whole history of this guy's life, this is what you're presenting to us? I don't think that, again, I think it's one of those areas where the defense may backfire because in the jurors' minds they're going to hear something like, give me something, wow, give me volunteerism, give me great schooling, give me great, work that he's done for other people, or things that separate him from these ridiculous, in my opinion, examples. And I find that a lot in death penalty litigation.
We are in a recess, so as soon as it comes back, we'll expect the defense to bring in more witnesses and try. It's going to be an interesting strategy. And talking about strategy, since Bob, I haven't had you on to talk about this case. The strategy by the defense attorneys here to reserve their right for an opening argument, they waited for the prosecution to close their case, and then they introduced this self-defense argument. They called one witness, and then they called Adam Matos. So they had really 2 witnesses to back this up. At the end of the day, it wasn't successful. Do you think they might have had a better chance? Maybe to at least one of those victims. Maybe they could have proved that it was self-defense for one of those victims, maybe even Nicholas Leonard. If they presented this case at the beginning, and then when each witness was coming forward, different medical experts, try to tease it out a little bit and said, isn't it possible this is evidence of a struggle? Something to have the jury sink their teeth into at the beginning, as opposed to just going at the end and seeing whatever sticks.
Yeah, so here's the maxiom that defense lawyers hold in death penalty litigation. If I can keep my client alive another hour, another minute, then it's a success to throw as many roadblocks as possible. In general speaking, you know this, Jesse, when you get up there and you're doing a criminal defense case, you really don't want to commit to a defense in the beginning. You want to argue that it's the state's burden and responsibility to prove its case beyond a reasonable doubt. We have you'll hear through cross-examination that our theory of the case is different than the prosecution's theory. You're very general, because once you open up, I've had this happen so many times in murder trials that I've had as a prosecutor, where the defense opens up to a particular defense and then, based on the evidence that comes out during the trial, has to change it, and then they've lost complete credibility in front of that jury. I personally think that the decision to put that defense on when they did it had nothing to do with the guilt phase. It was really directed at helping them in the penalty phase.
You're not the only one that thinks that. We've heard multiple people come on here and say that too. What I thought was interesting, look, from our perspective here at Law and Crime, we know more about the case than the jurors do, in the sense that we can read articles about it, we can read background information about Adam Matos. We have more information than is presented in court. We had an idea that the defense was going to bring in this idea that perhaps someone else committed this crime. This idea that Michelle Stinson, who is someone who allegedly was stalking Nicholas Leonard, one of the victims in this case, that they might go that route. That this is a woman who's obsessed with him, and maybe she took her, she killed the Browns because he had a romantic relationship with Megan. The problem is that you heard the defense try to introduce that fact on cross-examination of Daniel's father. They said, sir, do you know Michelle Stinson? Objection. It was outside the scope. What I thought from my perspective, I'm like, okay, that's one area they're going to try to go to, and then they abandoned that. They didn't go that. They didn't take that route any further. Right. And I thought that was interesting, because that is a character, Michelle Stinson or anybody outside, who was really not intimately involved with the events of this case, and bringing up that third party as someone who might have had something to involve, and then trying, if that didn't work, go to self-defense. I mean, it looked from our perspective, they were just trying to grab for whatever worked.
Yeah, so you're actually bringing the point as to why the defense doesn't open up and commit to a theory of a case, because many times I've seen this happen, and the defense doesn't realize that some of the evidence that they're going to try to point to a third-party guilt, is what we call third party, somebody else did it, is not admissible. And a lot of times they make the mistake in their opening statement thinking that that evidence is going to be allowed, that the judge is going to allow it. Here the judge didn't. So they basically had to change course, and that's why not committing themselves in the opening statement made sense, because they were credibly able to move to the self-defense piece. They made a tactical decision at that point in time. When the judge would not allow third-party guilt, third-party person that did this to come be introduced, they knew the evidence was overwhelming. They knew the likelihood of a conviction was almost certain. So let's throw him on the stand, talk about self-defense, talk about, I'm sorry, I'm remorseful, I didn't mean it to happen, I snapped, so that he's working and smoothing the jury out towards the penalty phase. And he can also say, hey, he was honest with you. And that's a powerful thing. He got up there, he didn't try to tell you that he didn't do it, he didn't try to say, that make an excuse where he got up there and told you credibly, ladies and gentlemen, the jury's an honest person, and for that, if nothing else, you should take that into consideration not to execute him.
Do you think the falling grace for him, the one part that he couldn't explain away, was the Margaret Brown killing, in the sense that, okay, if he had killed Nicholas Leonard, Gregory Brown, Megan Brown, all in the same time frame, like he claimed, he came home and did that and was defending himself, according to his testimony, he was defending himself from Nicholas Leonard, who had a gun, had his hand on his throat. There was a fight that ensued. He ended up killing him. Gregory Brown took out his gun, tried to shoot Adam Matos. He defended himself against Gregory. And then Megan Brown, who kept encouraging her father to shoot Adam, she was standing in the corner and she thought she had something in her hand and he thought it was a gun and he shot her too. Okay, you have those three killings. But then the problem is, you waited 6 hours? You waited hours in the house till Margaret Brown came home because you were paranoid, thought she was going to be a threat to you too, waited till she came home and killed her too? Isn't that really where it all went bad for the defense?
Of course. I mean, if they were even to believe his testimony in the first place, the fact that he is waiting for that period of time not only eliminates the defense of passion provocation, Jesse, as you know, because there's a significant period of time from the inciting event to the last murder here, but it shows that this was not really a self-defense thing. This was a revenge killing. This was, I'm going to take everybody out all the way from the if, and but of this case. So, yeah, I think that really hurt him a lot. I think he would have been better off tactically not trying to introduce the self-defense when he was on the witness stand, saying, I did it, but I did it because. I think it would have been better if he just said, look, I snapped, I wasn't thinking, I did these horrible things, and then he's still not going to have, he's going to have a very hard time getting around why he waited 6 hours until he killed the fourth person, right? So that's rough for him.
Are you saying it would have been possible maybe to get him down to second degree or something of that nature,
well,
as opposed to first?
If it's self-defense and they were to buy it, then 3 of them would be an outright outright acquittal on 3 people. The 4th one he's going to have a more difficult time explaining because so much time went by. Under the passion provocation law, however, if he was incited to the point where he wasn't thinking and he committed the murder, and if they follow the elements of passion provocation, it would reduce it from a murder to a manslaughter with a significantly less sentence.
Right. The defense was trying to get that. They were saying, listen, if you're going to find him guilty of anything, first of all, we think this is justifiable homicide for these 3 killings. If you find him guilty of anything, manslaughter, 2nd degree. You can't, it's not 1st degree. They conceded the fact, they stipulated, not even stipulated, they conceded the fact, they said, look, with Margaret Brown, you have to go with manslaughter. It didn't work out well. Bob, stand by. We do have a live feed right now in the Matos courtroom.
Sealing them for appellate purposes only, so they can't be reviewed, okay. Except by the appellate court. So if anybody, for any reason, wants them with lawyers, fine, is what I'm saying is you're going to have to do in order to have them seal them. Okay. For appellate purposes, they'll go to the appeals, but if for any reason someone wants to look at them for this proceeding, for any reason, or any further proceeding, I have to do an order to unseal them.
We're good for this proceeding.
Okay. So the reason I had to come back a little bit early was to go over the draft instructions that the state prepared for me and the verdict forms. Defense, I believe that you and your client have looked over the verdict form. Any objection to the verdict forms?
No.
Okay, so I'm going to give these. These are the originals. There's only 1 copy. So if you're looking for a copy, you don't have one, because I have the only copy.
No.
Oh, okay. I just want to make sure you are.
The final instructions, I don't know where I put them.
All right. You can take a moment and see if you can find them there.
I do have them.
All right. Do you have them?
Yes.
This is their objections to your final instructions. I gave you the order on their instructions. These are the objections to the final instructions. All right. On the final instructions, it looks like they went ahead and put in the mitigation that you've requested. It appears to be, at this point, 31 separate mitigators. And they did it the way I asked. They either put defendant or Adam Matos, his whole name.
Yeah, I went through it.
All right. Do you see, other than the objections that you've raised previously, do you have any additional objections to the instructions?
No, I don't believe so.
All right. So these are the instructions. I'm going to go ahead and read. At this point, I find that, and as a matter, we did the JOA argument at the bench, and so I did find that there is sufficient testimony and evidence to get the 2 aggravators of previous conviction for another capital felony without the judgment and sentence, and the 2nd aggravator of especially heinous, atrocious, and cruel. And so those are both in here. And then the mitigators are the age that Mr. Matos loves Tristan, dedication to Tristan, life in prison means life without the possibility of parole. Mr. Matos was raised by a single uneducated mother with a mental disability, never knew his dad, would leave him alone with his brother for extended periods of time, loves his brother, loves his mother, loves his extended family, grew up in poverty and experienced unstable home, grew up with experiencing his mother changing boyfriends, history of mental illness in the family. Have we got to that one yet?
No.
Okay. He was a slow learner. We got the asthma. The 2 weeks in South America.
That's coming.
Okay. I was going to say, I don't believe I heard anything about that. did get the plastic lines and a stick, bullied. We haven't heard about Nancy Matos' rehabilitation. Yes?
She's-
Oh,
she's,
high school. All right, at this point, we've either got them all in or you're saying they're coming, right?
I have every reason to believe.
Okay, we'll redo that. Is there anything else? I assume at this point, everything else is standard. Any objections that we haven't previously raised?
I don't think so.
Okay, so as long as, we'll do it one more time. I assume the state may have some argument about the mitigators if they don't, the rest of the witnesses don't go ahead and tie everything else up. But are your witnesses from Philadelphia ready to go?
Yes, they are next.
Okay, anything else we need to discuss before we bring the jury back up?
Were you going to talk to them about tonight or tomorrow?
I'm going to wait to see how far you get.
Okay.
I assume if all of your witnesses are ready, are done, and then at 3 o'clock we're ready for the person from out of state, then we might, at that break, I'm going to ask them if they'd like to stay, give them a 15-minute break to think about it. When they come back, they can give me the answer. So,
Well, we have 3 people right now in Philadelphia. We have 1 person who missed the flight and may be there. I don't know. Not going to be here. Okay. So we have actually 3 on this guy.
okay, I assume they're not too long.
No.
I mean, we've seen a couple of witnesses so far. They're no longer than any of the witnesses so far.
That would be a good estimate.
Okay, then, I mean, I think we did 3 in about 45 minutes this morning. So, other than that, state anything we need to discuss?
At this time, Judge, I do.
All right, then we'll bring the jury up. So they do that, Mr. Lugo, can I speak to you for a moment on something else unrelated?
Yes, sir.
And welcome back, everybody, to the Law and Crime Network. It looks like there's a brief sidebar going right now as we wait for the jurors to enter the courtroom. I'm alongside attorney Bob Bianchi. What do we expect this afternoon? The defense is going to be putting on more of their case. How can they avoid having the jurors put this man to death?
Well, again, the axiom for a defense lawyer is to do everything they can to preserve any kind of appellate argument so it can go all the way, hopefully, to the Supreme Court in their mind, to keep him alive for as long as possible. That's the goal of death penalty litigation defense lawyers. And what they're going to do is put a number of experts on. They're going to try to pull on the heartstrings of people who, in my experience as a death penalty prosecutor, even though, I was saying to Jesse before, Rachel, that even though all those jurors are death qualified, which means they all said that they could impose the death penalty if the state proves it beyond a reasonable doubt, you as a prosecutor know that when the judge reads a jury charge at the end and says each one of you individually not only has to find the aggravating factors, but that the death penalty is an appropriate sentence. And even the most adamant supporters of the death penalty, when they have to make the unique decision to execute a person, take a step back a little bit, especially if the defense does a good job at saying, hey guys, to the jury, ladies and gentlemen, jury, life in prison is a far greater penalty and torture essentially to the guy than execution. Now, as prosecutors, we always say, well, no, the death penalty is the ultimate penalty and it takes years and years and years, so why not have both? Unfortunately, they're not allowed to make that argument to the jurors.
So let's talk a little bit here about those aggravating factors that they're going for in this trial, because they really laid forth 2. And one is that he was convicted of capital murder, and they used the fact that he was convicted of these 4, that you can rely on one to aggravate the other, basically. And 2, that these crimes were especially heinous and atrocious. How does a prosecutor go about proving what, you know, a layman or a juror might seem, especially for the second aggravating factor, to be a somewhat subjective factor?
This case is unique because it's a hammer in some of the instances.
Right.
And hammer's really intimate, as we would like to say. It's like stabbing. This is a really brutal way to kill somebody. This isn't pulling a gun out and just shooting somebody and the person just immediately dies. You have to kind of be hacking away at somebody in order to accomplish the goal here. The prosecutors clearly want to emphasize, of all aggravating factors, the most, the cruel and heinous nature of these murders multiplied over and over and over again, because we all know from death penalty litigation that with that aggravating factor above all others is the most persuasive to jurors.
And that's part of the reason probably we saw the prosecution put Dr. Noel Palma, the medical examiner, on the stand to talk about kind of the heinous nature and how much pain the victims must have gone through during the course of this crime.
Well, if you're a good prosecutor or a good lawyer in general, there is no mystery that you are purposely plotting your witnesses in a timeline in order to have the greatest impact on jury. Primacy and recency are the two greatest things that you can look for, and so you want to wow them in the beginning of that penalty phase with the most important witness, with the most important aggravating factor, and that's exactly what the prosecution did here.
So again, though, like you just were saying, you know, you really think you have a case that's so brutal, so heinous, 4 people dead, but a lot of times jurors at the last moment, well, especially when the guy took the stand, they got to know him a little bit, they might have second thoughts.
Yeah, I think that the move, like I was saying before, was a tactical one by the defense. I don't think that they necessarily thought the jury was going to buy any kind of self-defense or whatever, but I thought it was to humanize the man in front of the jury, to listen to him testify, to listen to see a real live human being, to listen to some problems that he's had in his life, because it's much harder when you've humanized a person to push the button on them to be executed. Big decision for the jurors to make, and I think that that's the reason he took the stand in the guilt phase of this case.
Although, you know, some others could argue it might have actually hurt his case because of the way he appeared on the stand, so stoic, so without emotion.
Yeah.
I mean, he didn't even really seem to get upset when he was describing really brutally killing these people.
Yeah, you know.
So it might have backfired.
Yeah, you dance with the one you brought, they like to say, and unfortunately for the defense, that's their client, and I agree with you completely. I mean, you wonder, how's my client going to respond on the stand? I've had clients that I've had on the witness stand really different than the way that you think they would appear or the way they talk prior to putting them on. You want to make sure he's animated. You want to make sure that the jurors relate to him, and I'm not certain that he did it, so it may very well have backfired.
Bob, thank you so much. Stick around for a few more minutes. It looks like we're getting some action in the courtroom, so let's take a listen to what the judge is saying.